5. The maintenance of peace and order, the protection of life, liberty, and property, and promotion of the general welfare are essential for the enjoyment by all the people of the blessings of the democracy. The police power of the state, the concepts. Police power is the power of the state to promote public welfare by restraining and regulating the use of liberty and property. It is the most pervasive, the less limitable, and the most demanding of the three fundamental powers of the state. As an inherent attribute of the sovereignty, which virtually extends to all public needs, police power grants a wide panoply of instruments through which the state, as parens patriae, gives effect to the hosts of its regulatory powers. We have held that the power to regulate means the power to protect, foster, promote, preserve, and control with due regard to the interests, first and foremost of the public, then of the unity of the patrons. For the general welfare, the state, in order to promote general welfare, may interfere with personal liberty, with property, and with business and occupations. Persons may be subjected to all kinds of restraint and burdens in order to secure the general comfort, health, and posterity of the state is fundamental aim of our government, the rights of the individual and subordinated. The extent of police power. Generally, police power extends to all great public needs. It is particular aspects, public health, public morals, public safety, and public welfare. The requisites for a valid exercise of police power. First, there must be a lawful subject, the interest of the public generally, as distinguished from laws of a particular class, require the exercise of the police power. And second, the presence of lawful means employed that are reasonably necessary for the accomplishment of the purpose, and the unduly oppressive upon individuals. Declaring a state of calamity and ordering closure of barangay. Again, declaring a state of calamity and ordering a closure of Boracay, a valid exercise. The assailed government measure in this case, within the scope of police power cannot be disputed, whereby the statutes from which the said measure draws authority and the constitutional provisions which serve as its framework and primarily concerned with the environment and health, safety, and well-being of the people. The promotion in health, safety, and well-being of the people, the promotion and securing of which are clearly legitimate objectives of the governmental efforts and the regulations. The only question now is whether the temporary closure of Boracay as a tourist destination for 6 months reasonably necessary under the circumstances. The answer is in the affirmative. Tourist arrival in the island were clearly far more than Boracay could handle. Certainly, the closure of Boracay, albeit temporarily, give the island its much-needed breather and likewise afforded the government the necessary leeway and its rehabilitation program. Note, policies, the bulk of rehabilitation activities involve inspection, testing, demolition, relocation, and construction. These works could not have easily been done with tourists present. The rehabilitation works in the first place were not simple, superficial, or mere cosmetic, but rather quite complicated, major, and permanent in character. They were intended to serve as long-term solutions to the problem. Increase of license fees and inspection rule of establishment valid exercise. The mantle of protection associated with the due process guarantee does not cover the hotel and motel operators. This particular manifestation of a police power, measure being specifically aimed to safeguard public morals, is immune from from such imputation of nullity resting purely on conjecture and unsupported by anything of substance. To hold otherwise would be to unduly restrict and narrow the scope of police power, which has been properly characterized as the most essential, insistent, and the less limitable of powers extending as all great public needs, there is no question that the Challenge Ordinance was precisely enacted to minimize certain practices harmful to public morals. The Challenge Ordinance then proposes to check the clandestine harboring of transients and guests of the establishment by requiring these transients and guests to fill up registration forms prepared for the purpose in a lobby open to public at all times, and by introducing several other mandatory provisions calculated to shatter the privacy that characterizes the registration of transients and guests. Moreover, the increase of the license fees was intended to discourage the establishment of the kind from operating for purpose other than legal, and at the same time to increase the income of the city government. The hotel short time prohibition invalid. The hotel short time prohibition invalid. A reasonable relation must exist between the purposes of the measure of the means employed for its accomplishment. For even under the guise of protecting the public interest, personal rights, and those pertaining to private property will not be permitted to the arbitrarily invaded. It must also property will not be permitted to arbitrarily invaded. It must also be evident that no other alternative for the accomplishment of the purpose less intrusive of private rights can work. In the present case, there is less intrusive measures which can be employed, such as carving out of the prostitution and drug use through active police force. The ordinance has a lawful purpose but does not have the lawful means, hence unconstitutional. The public utilities charges subject to state regulation. Public utilities charges subject to state regulation. Public utilities charges subject to state regulation. The regulation of the rates to be charged by the public utilities is founded upon the police powers of the state and statutes prescribing rules for the control and regulation of the public utilities are valid exercise thereof. When private property is used for public purpose and is affected with public interest, it ceases to be private. It ceases to be juris privati only and becomes subject to regulation. The regulation is to promote the common good as long as use of the property is continued. The same is subject to public regulation. Compelling mall operators to provide free parking to customers invalid. So mall owners and operators cannot be validly compelled to provide free parking to their customers because requiring them to provide free parking space to their customers is beyond the scope of police powers. It is unreasonably restricts the right to use property for business purposes and amounts to confiscation of property. The requisites for the valid exercise of police power by the delegate, there must be an express grant by law. It must not contrary to law, and generally, it must be within territorial limits of LGUs except when exercised to protect water supply. The courts cannot interfere within the exercise of police power if the legislature decides to act. The choice of measures or remedies lies within the exclusive discretion as long as the requisites for a valid exercise of police power have been complied with. The MMDA cannot exercise police power. Again, MMDA cannot exercise the police power. The MMDA cannot exercise the police powers since its powers are limited to the formulation, coordination, regulation, implementation, preparation, management, monitoring, setting of policies, installing a system, and administration. Nothing in RA 7924 granted that the MMDA police power let alone legislative power. To the statutory right to bear arms, the right to bear arms is a statutory, not a constitutional right. The license to carry a firearm is neither a property nor a property right. Neither does it create a vested right. Even if this were a property right, it cannot be considered absolute as to be placed beyond the reach of police power. The maintenance of the peace and order and the protection of the people against violence are constitutional duties of the state, and the right to bear arms is to be construed in connection and in harmony with these constitutional duties. In section number 6, the separation of church. Section number 6, the separation of the church and state shall be inviolable. The history of the Union and eventual separation. Before our country fell under American rule, the blanket of Catholicization. Again, the history of the Union and eventual separation. Before our country fell under American rule, the blanket of Catholicism covered the archipelago. There was a union of church and state, and Catholicism was the state religion under the Spanish Constitution in 1876. Civil authorities exercise religious function as the friars exercise civil powers. Catholics alone enjoy the right of engaging in public ceremonies of worship, although the Spanish Constitution itself was not extended to the Philippines. Catholicism was also to establish churches in the country under the Spanish rule. Catholicism was in fact protected by the Spanish Penal Code of 1884, which was in effect in the Philippines. Some of the offenses in Chapter 6 of the Penal Code entitled Crimes Against Religion and Worship referred to crimes against the state religion. The coming of the Americans to our country, however, to our the coming of the Americans to our country, however, changed this state charge scheme for with the advent of this regime. The unique American experiment of separation of church and state was transported to the Philippine soil. Even as early as the conclusion of the Treaty of Paris between the United States and Spain on December 10, 1898, the American guarantee of religious freedom had been extended to the Philippines. The treaty provided that the inhabitants of the territories over which Spain relinquishes or cedes her sovereignty shall be secured in the free exercise of religion. Even the Filipinos themselves guaranteed religious freedom a month later or on January 22, 1899, upon the adoption of the Malolos Constitution of the Philippine Republic under General Emilio Aguinaldo. It provided that the state recognizes the liberty and equality of all religion, de todos los cultos, in the same manner as the separation of the church and state. But the Malulu's constitution and government was short-lived as the Americans took over of the reins of government. In Section 7, the state shall pursue an independent foreign policy and relations with other states that paramount consideration shall be national sovereignty, territorial integrity, national interest, and the right to self-determination. Again, Section 7, the state shall pursue an independent foreign policy and its relations with other states that the paramount consideration shall be national sovereignty, territorial integrity, national interest, and the right to self-determination. In section number 8, the Philippine consistent with the national interest adopts and pursues a policy of freedom from nuclear weapons in its territory. Again, section number 8, the Philippines consistent of the national interest adopts and pursues a policy of freedom from nuclear weapons in its territory. Section number 9, the state shall promote a just and dynamic social order that will ensure the prosperity and independence of the nation and free of the people from poverty through policies that provide adequate social services, promote full employment, a rising standard of living, and an improved quality of life of all. Section number 9, the state shall promote just and dynamic social order that will ensure the prosperity and independence of the nation and free for the people from poverty through policies that provide adequate social services, promote full employment, a rising standard of living, and an improved quality of life for all. Section number 10, the state shall promote social justice in all phases of national development. Section number 10, the state shall promote social justice in all pieces of national development. Section number 11, the state values the dignity of every human person and guarantees full respect for the human rights. Section number 11, the state values the dignity of, of every human person and guarantees full respect for human rights. Section number 12, the state recognizes the sanctity of family life and shall protect the strengthening the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of the unborn from conception, the natural primary right and duty of parents in training of the youth for civic efficiency and the development of moral character shall receive the support of the government. Again, the state recognizes the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of the unborn from conception, the natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. Section number 13. Section number 13. The state recognizes the vital role of the youth in nation building and shall promote and protect their physical, moral, spiritual, intellectual, and social well-being. It shall inculcate in the youth patriotism and nationalism and encourage their involvement in public and civic affairs. Again, section number 13, the state recognizes the vital role of the youth in nation building and shall promote and protect their physical, moral, spiritual, intellectual, and social well-being. It shall inculcate in the youth patriotism and nationalism and encourage their involvement in public civic affairs. In RA In RA 7610, which penalizes child prostitution and other sexual abuses, was enacted in the policy of the state to provide special protection to children from all forms of abuse. Thus, the court grants the victim full vindication and protection granted under the law. Section number 14. The state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. Section number 14. The state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. Section number 15. The state shall protect and promote the right to health of the people and instill health consciousness among them. Section number 15. The state shall protect and promote the right to health of the people and instill health consciousness among them. Section number 16. Section number 16, the state shall protect and advance in the right of the people to balance and healthful ecology in accord with the rhythm and harmony of nature. Again, section number 16, the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. On the Clean Water Act, our legislators saw the need for a connected or concerted effort of the government and society to abate, control, and prevent the pollution of the country's water resources. Hence, the Clean Water Act was enacted in the hope that this vital measure will offer the future generation an abundant supply of potable water, clean rivers to swim, and a better access to safe water for their daily use. Section number 17. The state shall give priority to education, science, section number 17. The state shall give priority to education, science and technology, arts, culture, and sports to foster patriotism and nationalism, accelerate social progress, and promote total human liberation and development. Again, section number 17, the state shall give priority to education, science and technology, arts, culture, and sports to foster patriotism and nationalism, accelerate social progress, and promote total human liberation and development. Section number 18. The state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. Again, section number 18. The state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. Section number 18. The state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. Section number 19, the state shall develop a self-reliant and independent national economy effectively controlled by the Filipinos. Section number 19, the state shall develop a self-reliant and independent national economy effectively controlled by Filipinos. Section number 19, the state shall develop a self-reliant and independent national economy effective controlled by the Filipinos. Section number 20, the state recognizes the indispensable role of the private sector, encourages private enterprise, and provide incentives to needed investment. Section number 20, the state recognizes the indispensable role of the private sector, encourages private enterprise, and provides incentives to needed investment. Section number 20, the state recognizes the indispensable role of the private sector, encourages private enterprise, and provides incentives to needed investments. Section number 21, the state shall promote comprehensive rural development and agrarian reform. Section number 21, the state shall promote comprehensive rural development and agrarian reform. Section number 21, the state shall promote comprehensive rural development and agrarian reform. Section number 22, the state recognizes and promotes the rights of the indigenous cultural communities within the framework of national unity and development. Section number 22, the state recognizes and promotes the rights of the indigenous cultural communities within the framework of national unity and development. Section number 23, the state shall encourage non-governmental community-based or sectoral organizations that promote the welfare of the nation. Section number 23, the state shall encourage non-governmental community-based or sectoral organizations that promote the welfare of the nation. In section number 24, the state recognizes the vital role of the communication and information of the nation building. Section number 24, the state recognizes the vital role of communication and information of the nation building. Section number 25, the state shall ensure the autonomy of local government. Section number 25, the state shall ensure the autonomy of local government. Section 26, the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. Section number 26, the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. Section number 27, the state shall maintain honesty and integrity in the public service and take positive and effective measure against graft and corruption. Section number 27, the state shall maintain honesty and integrity in the public service and take positive and effective measures against graft and corruption. Section number 27, the state shall maintain honesty and integrity in the public service and take positive and effective measures against graft and corruption. Section number 28, subject to reasonable condition prescribed by law, the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. Section number 28, subject to reasonable conditions prescribed by law, the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. Okay, the Article 3 of the 1987 Constitution, the Bill of Rights. To Article 3 of the 1987 Constitution, the Bill of Rights. Effect of the 1986 February Revolution of the Bill of Rights in the 1973 Constitution. The 1986 February Revolution was done in the defense of the provision of the 1973 Constitution. The resulting government was indisputably a revolutionary government bound by no constitution or legal limitation except treaty obligations that the revolutionary government, as the de jure government, assumed under international law. The Bill of Rights under the 1973 Constitution was inoperative during this period. It was abrogated by the revolutionary government. But since the Philippines is a signatory to the International Covenant on Civil and Political Rights, in the Human Declaration of Human Rights, the protection accorded to individuals under the same remain in effect even without the 1973 Constitution. The ways the BOR is strengthened by the new Constitution, there are several ways in which the Bill of Rights is strengthened in 1987 Constitution. Number 1, new rights are given explicit recognition such as the prohibition against detention by reason of political beliefs and aspirations. The waiver of Miranda rights is now required to be made in writing the assistance of counsel. The use of the solitary and communado and secret detention places is prohibited, while the existence of the substandard and inadequate penal facilities is made the concerned legislation. Number 2, there is also recognition of the right of expression, an express prohibition against the use of torture, a mandate to the state to provide compensation and rehabilitation for victims of tortures and families. Number 3, some rights have been expanded. For instance, free access to courts now include access to quasi-judicial bodies and to adequate legal assistance. Number 4, the requirement for interfering some rights have been made more strict. For instance, only judges can now issue search warrants or warrants of arrest. There must be a law authorizing the executive department to interfere with the privacy communication, the liberty of abode, and the right to travel before these rights may be impaired or curtailed. Number 5, the Constitution now provides that the suspension of the privilege of the writ of habeas corpus does not suspend the right to bail, thus resolving a doctrinal dispute of long standing. Number 6, the suspension of the privilege of the writ of habeas corpus and the proclamation of martial law have been limited to 60 days and now subject to the power of the Congress to revoke. In addition, the Supreme Court is given the jurisdiction upon the possession of any citizen to determine the sufficiency of the factual basis of the suspension of the privilege of the writ of habeas corpus and proclamation of martial law. Number 7, the Supreme Court is empowered to adopt rules for the protection and enforcement of the constitutional rights. Number 8, in Article 2, Section 11, commits the state to policy which places value on the dignity of every human person and guarantees full respect for human rights. Letter A Commission on Human Rights is created under Article 16, Section 5, Paragraph 2. The state is mandated to promote respect for the people's right among the members of the military and the performance of their duty. The basic purpose of the Bill of Rights, the purpose of the Bill of Rights is to protect the people against arbitrary and discriminatory use of political power. This bundle of rights guarantees the preservation of our national rights, which include the personal liberty and security against invasion by the government or any of the branches instrumentalities. Certainly, in the hierarchy of rights, the Bill of Rights takes precedence over the right of the state to prosecute and when weigh against each other, the scales of justice tilt towards the former. Thus, relief may be availed of to stop the purported enforcement of criminal law where it is necessary to provide for an orderly administration of justice to prevent the use of the strong arm of the law in an oppressive and vindictive manner and to afford the adequate protection to constitutional rights. In Section 1, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. Again, Section number 1, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protections of the laws. What does life include? Life includes the right of an individual to his body and its completeness, free from dismemberments and extends to the use of God-given faculties, which make life enjoyable. Again, what does life include? Life includes the right of an individual to his beauty and its completeness, free from dismemberment and extends to the use of God-given faculties, which make life enjoyable. A decent and dignified life. Right to life is not just a protection of the right to be alive or to be security of one's life against physical harm. The right to live is the right to a good life, a life of dignity, and a decent standard of living. What does liberty include? Liberty includes the right to exist and the right to be free from arbitrary personal restraint or servitude. It includes the right of the citizen to be free to use his faculties in all lawful ways. When value of a thing is destroyed, already a deprivation, a person is deprived of his property not only when it's physically taken from him, but also when its value is destroyed or when its capability for enjoyment or its adaptability to some particular aspects is impaired. There is deprivation of property without due process of law where the owner is constrained to devote it wholly or in part of public use without just compensation. The due process of law. Due process of law is attained in a law which hears before it condemns, which proceeds upon inquiry, and renders judgment only after trial. It is responsive to the supremacy of reason, obedience to the dictates of justice. It is embodiment of the sporting idea of fair play. The requisites of procedural due process and judicial proceedings. The requisites of procedural due process and judicial proceedings are: number 1, an impartial court of tribunal cloth with judicial power to hear and determine the matters before it Number 2, the jurisdiction properly acquired over the person of the defendant and over the property, which is the subject matter of the proceeding. Number 3, the opportunity to be heard. And number 4, judgment rendered upon lawful hearing and based on evidence adduced. The jurisdiction. While jurisdiction over the person of the defendant can be acquired by the service of summons, it can also be acquired by voluntary appearance before the court, which includes submission of pleading in compliance with the order of the court or tribunal. It should be emphasized that the service of summons is not only required to give the court jurisdiction over the person of the defendant, but also to afford the latter the opportunity to be heard on the claim made against him. Thus, compliance with the rules regarding the service of summons is as much an issue of due process of jurisdiction. The opportunity to be heard. Due process is satisfied as long as the party is accorded the opportunity to be heard. If it is not availed of, it is deemed waived or forfeited without violating the constitutional guarantee. To be heard does not only mean verbal agreements. In court, it does not necessitate a trial type hearing or may be heard also through pleadings. Where opportunity to be heard, either through oral arguments or pleadings, is accorded, there is no denial of procedures due process. Those due process in labor cases before labor arbitration is satisfied when the parties are given the opportunity to submit their possession papers to which they are supposed to attach all the supporting documents or documentary evidence that would support their respective claims. Ay, sorry. The enjoyment equality principle. This merely means equality in the enjoyment of similar rights and privileges granted by law. It means that no person or class or of persons shall be denied the same protection of the law, enjoy the same class. It does not, however, guarantee economic equality, but not only equality before the law. Again, the enjoyment equality principle, it merely means equality in the enjoyment of similar rights and privileges granted by law. It means that no person or class of persons shall be denied the same protection of the law enjoyed by the same class. It does not, however, guarantee economic equality, but only equality before the law. Sana all principle. The Sana All Principle, when Benigno Aquino III ascended the presidency, he issued Executive Order Number 1, creating the Philippine Truth Commission to investigate the graft and corrupt practices to the previous administration of Macapagal Arroyo. The Supreme Court held that it should be struck down as violative of the Equal Protection Clause. The clear mandate of the Invention Truth Commission is to investigate and find out the truth concerning the reported cases of graft and corruption during the previous administration only. The intent to single out the previous administration is plain, patent, and manifest. The 3-year prohibition of surviving spouse provision invalid. In declaring the as invalid in Section 18 of PD 1146, which provides that surviving spouse has no right to survivorship pension benefits if the surviving spouse contracted marriage with the pensioner within 3 years before the pensioner qualified for the pension. The Supreme Court said that the classification does not rest on substantial distinction. If the purpose of the proviso is to prevent deathbed marriages, there is no reason why the proviso recons the 3-year provision from the date the prisoner qualified for the pension, not from the date of pensioner died. It lumps all marriages contracted within 3 years before the pensioner qualified 18 permission as having been contracted primarily for finance convenience. The standard test of judicial review. Rational basis test. The rational basis is described as adopting a differential attitude towards legislative classifications. The difference comes from recognition that classification is often unavoidable elements of the task of legislation, which under the separation of powers embodied and Constitution is primarily the prerogative of Congress. It applies to legislative classification in general, such as those pertaining to economic social legislation. And section number 2, the right of the people to be secure in these persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall be issued except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses. He may produce and particularly describing the place to be searched and persons or things to be seized. A person, again, section number 2, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witness he may produce and particularly describing the place to be searched and the persons of or things to be seized. The protection is available to all persons, including aliens, whether accused of a crime or not. Artificial persons are also entitled to guarantee, although they may be required to open their books of accounts for examination by the state of the exercise of police and taxing powers. A personal right. The right of personal, it may be invoked only by the personal entitled to it. As such, the right may be waived either expressly or impliedly, but the waiver must be made by the person whose right is invaded, not by who one is not truly authorized to effect such waiver. The valid warrant. A valid warrant must have the following requisites. Number one, it must be issued upon probable cause. Number two, probable cause must be determined personally by the judge. Number three, such judge must examine under oath of affirmation the complaint in the witness he may produce. Number four, the warrant must particularly describe the place to be searched and the person to be thing to be. Number probable cause, scope. Such facts and circumstances antecedent to the issuance of the warrant that in themselves are sufficient to induce a cautious man to rely on them and act in pursuance thereof. As a condition for the issuance of warrant, probable cause is such reason supported by the facts and circumstances as will warrant a cautious man to believe that his action in the means taken in prosecuting it is legally just and proper. The warrantless arrest, warrantless arrest. When lawful, arrest without warrant when lawful. A peace officer or a private person may, without a warrant, arrest a person. Letter A. When in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Letter B. When an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. And letter C. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or is temporarily confined with while his case is pending or has escaped while being transferred from one confinement to another. in flagrante delicto doctrine. When a police officer sees the offense, although at a distance or hears the disturbances created thereby, and proceeds to one and proceeds at once to the scene thereof, he may effect an arrest without a warrant. The offense is deemed committed in the presence of or within the view of the officer. Hot pursuit doctrine. The arrest of the accused inside his house following hot pursuit of the person who committed the offense in flagrante was held valid. Allowable warrantless searches. Warrantless search incidental to a lawful arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may be used as proof of the commission of an offense without a search warrant. The prevailing rule is that arresting officer may take from the arrested individual any money or property found upon the latter's person that which was used in the commission of the crime or was the fruit of the crime, or which may provide the person arrested with the means of committing violence or escaping, or which may be used in evidence in the trial of the case. The search must, however, be contemporaneous to the arrest and made within a permissible area of search. Section number 3. The privacy of communication and correspondence shall be inviolable except lawful order of the court or when public safety or order requires otherwise as prescribed by the law. Number 2, any evidence obtained in violation of this of the preceding section shall be inadmissible for any purpose in any proceeding. Again, section number 3. Number 1. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by the law. Number 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. The factors considering the existence of violation and evaluating a claim for violation of the right to privacy, a court must determine whether a person has exhibited a reasonable expectation of privacy and if so, whether the expectation has been violated by unreasonable government intrusion.